Greetings of the day. Today, we as a group are doing a group discussion on the topic use of force and humanitarian intervention in international law. I am Saurabh and present with me are
I'm Vineet. I'm Chandrakishore.
I'm Mustafa. I'm Yash.
I'm Pradyuman.
I am Neetu Gulati.
And I'm Ashwini Kumar.
Thank you.
Good afternoon, everyone. I want to start with a simple question. What stops a powerful country from simply bombing a weaker one into submission? Money, military defense, fear. The answer international law gives us is a piece of paper called the UN Charter. And today, I want to tell you why that piece of paper matters more than army. In 1945, the world was crawling out of the wreckage of two world wars. 50 million people were dead, cities were rubble, and the world leaders sat down and wrote Article 2 Clause 4 of the UN Charter, which declared that all the member states shall refrain from threat or use of force against the territorial integrity or political independence of any state. Not just some states, not just weaker states, any state. This was revolutionary. For the first time in history, war was not just morally wrong, it was legally prohibited. But here it gets complicated. Article 51 carved out an exception. A state has an inherent right of self-defense if an armed attack occurs against it. And Chapter 7 of the Charter gave the Security Council the power to authorize collective force when there is a threat to international peace and security. So we have a system, prohibition of force as the rule, self-defense and UNSC authorization as the exception. Now, how did the ICJ interpret this framework? In the landmark case, Nicaragua versus USA, case of 1986, the court drew a crucial distinction. The US argued that it was acting in collective self-defense of El Salvador. The ICJ said, not so fast. For collective self-defense to be lawful, there must be an armed attack. The victim state must request assistance and response must be necessary and proportionate. The US failed all three tests. The ICJ found that US had violated international law by mining Nicaragua's harbors, arming the Contras, and attacking Nicaraguan oil installations. Why? What makes this remarkable is what happened next. The USA simply refused to comply with the judgment. It withdrew from the case mid-proceedings and vetoed the Security Council resolution that has the enforcing ruling. This tells us something crucial. The legal framework exists, but enforcement depends on political will. We also have the earlier Corfu Channel case of 1949, the very first case of the ICJ ever decided. But the court ruled that even if a state does not actively commit an act of force, it can be responsible if it knowingly allows its territory to be used for harm against another state. And even the considerations of humanity, the court said bind every state. So to summarize, the Charter framework is not a suggestion, it is a binding international law. The prohibition is broad, the exceptions are narrow, and the ICJ has consistently enforced these limits, even against the world's most powerful nations. The question for this discussion is, in a world where great powers routinely test these limits, does this framework still have teeth?
Allow me to pose a moral dilemma. Our government is slaughtering its own citizens. Thousands are dying. The Security Council is deadlocked. No authorization for force is coming. Do neighboring states, do all of us, just watch. International law traditionally says yes, we watch, because sovereignty demands it. The classical doctrine of state sovereignty, rooted in the 1648 Peace Treaty of Westphalia, holds that what a government does within its own boundaries is its own business. Non-intervention is enshrined in Article 2.7 of the UN Charter, and for much of the international legal history, this shield was absolute. But sovereignty was never designed to be a license to massacre. The Kosovo crisis of 1999 broke this paradigm. NATO bombed Serbia without Security Council authorization to stop ethnic cleansing against Kosovar Albanians. Was it legal? Strictly under the UN Charter? No. Was it morally defensible? Maybe so. Security Council at that time famously said the intervention was illegal but legitimate. Then in 2010, the ICJ weighed in on the Kosovo situation through its advisory opinion of its unilateral declaration of independence. The court, by a majority of 10 to 4, found that Kosovo's declaration of independence did not violate the international law. Crucially, the court noted that unilateral declarations of independence are not generally prohibited by the international law, leaving the door open for self-determination claims in extreme humanitarian situations. But notice what the ICJ carefully avoided. It did not validate NATO's military intervention. It did not say humanitarian intervention without emergency authorization is legal. It addressed only the narrow question of independence. The judicial restraint in itself is telling. The court knew that the intervention question was a political minefield. Now, here is the tension on the heart of this debate. The responsibility to protect doctrine adopted by all UN member states at 2005 World Summit states that sovereignty entails responsibility. A state that fails to protect its population from genocide, war crimes, or crimes against humanity loses this shield of sovereignty. And the international community has the responsibility to act. Sounds simple, but this doctrine is a political declaration, not a legally binding treaty. It has no enforcement mechanism of its own. And when it was invoked for Libya in 2011, the intervention went well beyond protecting civilians. It became a regime change. Russia and China felt deceived. They have cited Libya ever since to justify blocking every subsequent humanitarian resolution. So where does this leave us? Humanitarian intervention without authorization may sometimes feel morally necessary, but as a legal principle, it is deeply contested and dangerously open to abuse. The challenge for international law is to build a framework that can respond to atrocities without becoming a tool for powerful states to topple governments they dislike.
Great argument. But if we look at it from another perspective, in 2005, the United Nations made a promise. Every single member state, 191 countries, they stood up and said, we accept that sovereignty is not a blank check. We accepted that if a state commits genocide, war crimes, ethnic cleansing, or crimes against humanity and fails to stop them, the international community has the responsibility to protect the victims. This was called the Responsibility to Protect, or R2P. It was supposed to be the legal and moral answer to the failures of Rwanda in 1994, where more than 800,000 people were killed while the world watched. And yet, 2 decades later, the question we must ask is, has R2P delivered? Let us be very honest. The record is mixed. R2P was successfully invoked in the Quartet del Nord and Libya initially. But the Libya intervention of 2011 haunts the doctrine to the day. UNSC Resolution 1973 authorized force to protect civilians. What followed was the complete destruction of the Gaddafi government and the regime change there. Sometimes, the resolution never authorized. Russia and China, who had absent to allow the resolution to pass, felt the mandate was betrayed. Since then, they have consistently vetoed every attempt to invoke Chapter 7 of humanitarian purposes, most devastatingly in Syria. This brings us to the most painful case of R2P, the ICJ's ongoing proceedings in South Africa versus Israel. In January 2024, the ICJ ordered provisional measures finding it plausible that Israel's actions in Gaza could constitute genocide or the Genocide Convention. The court ordered Israel to take all measures possible to prevent acts covered under Article 2 of the Convention, including killing members of the group, causing seriously bodily or mental harm, and deliberately inflicting conditions calculated to bring about physical destruction. Sorry, everyone. Now, R2P should have killed it. The international community should have acted collectively and disclusively. Instead, the US vetoed multiple security resolutions. The provisional measures have gone largely unimplemented. The court had to issue a second and then a third set of orders, growing increasingly alarmed at the deteriorating humanitarian situation. This is the paradox of R2P. It exists as a norm, but powerful states they selectively apply it according to their own mind. The doctrine is wielded against weak, geopolitically isolated governments and quietly shelved when allies are in the dock. The selective application is perhaps the greatest threat to R2P's legitimacy. What R2P needs to become is a genuine rule of law, and not just a rule of convenience. It is an independent trigger mechanism, automatic UN response procedures, and equal application regardless of who the violating state's friends are. Until then, it remains more aspiration than law.
The UN Security Council and veto paralysis. Imagine a fire brigade. Their job is to put fires, but every time there is a fire, 5 of the firefighters get personal into whether to respond. And those 5 firefighters also own properties near the fire. Would you trust the fire brigade? Ladies and gentlemen, this is the new United Nations Security Council. The Security Council have 5 permanent members: US, UK, France, Russia, and China, collectively known as the P5. Each holds a veto power and substantive resolution. The veto was designed in 1945 to ensure that the major power would not abandon the UN the way they have abandoned the League of Nations. The logic was, if the great powers have guaranteed stake in the system, they will stay in it. The logic made sense in 1945. Today, it is paralyzing the system. The numbers speak for themselves. Since 1946, the veto has been used over 293 times. Russia alone has cast 120 vetoes, nearly half all since 2011. Russia cast 19 vetoes, 14 out of them on Syria. The US has used its veto 82 times and frequently to shield Israel from accountability resolutions. The consequences in Syria were catastrophic. Despite documented use of chemical weapons by Assad regime, despite reports of torture, starvation of civilians, and barrel bombs dropped on hospitals, the Security Council was unable to make meaningful action for a decade, with Russia, sometimes joined in China, repeatedly blocking every attempt at accountability. Hundreds of thousands of people have died in the legal vacuum. Now, there are defenders of the veto. Russia itself, in UN General Assembly debates, has argued the veto has prevented Council from being used as a rubber stamp for Western military adventures. There is something to this. The veto also blocked resolutions that would have authorized penalties, destabilizing intervention. But the ICJ has actually weighed on the limits of Council power in an important way. In the Nambia Advisory Opinion of 1971, the court interpreted Security Council resolutions broadly affirming the Council's far-reaching powers, but implicitly also confirming that the Council authority is bounded by the Charter and the preemptory norms of international law. The Council cannot, for instance, authorize genocide even by unanimous vote. Reforms are urgently needed. France and Mexico have proposed a veto restraint code, a voluntary pledge by P5. Members do not use the veto in case of mass atrocities. Over 100 of states have endorsed it, but none of the P5 have formally come. The US, Russia, and China have opposed any formalities, limitation on veto power. Here is the uncomfortable conclusion. The Security Council, as currently structured, is constitutionally incapable of enforcing international law against the interest of any of one of its 5 permanent members.
Good afternoon, speakers. Very well opined. The questions that you all raised are certainly of importance, but what I propose to be discussed is the question of, can states use force against non-state actors on foreign soil? To begin with, I have an email. On the morning of September 11, 2001, 19 men boarded planes and changed international law forever. Not because what they did, but because of what governments did in response. Here is the problem. The September 11th exposed in stark terms the entire framework of the UN Charter. Article 2, Subclause 4 and Article 51 of Chapter 7 were designed for wars between states. State A attacks State B, and State B protects itself, clean, simple, and covered. But what happens when State B is attacked by not any other state, but by a non-state actor or a terrorist group? The UN Charter is not clear on this. Operation from the terrorist or a third country or State C. Can State B use force inside State C to eliminate that group? Or can State C unwittingly or unable to attack against the group itself? Bring this to the present day. Israeli military campaign in Gaza following the Hamas attack on October 7, 2023 has generated perhaps the most intense legal debate this doctrine has ever faced. Israel has invoked Article 51 in self-defense, but Gaza is not a state. Hamas is not a state actor, as we all know. And the ICJ's provisional measure in the South Africa versus Israeli case effectively placed obligations on Israel under the Genocide Convention obligations that sit in direct tension with the Israel self-defense claims. This is the bleeding edge of the international law rights now. The old rules did not fight the new threats, but the solution cannot be simple to abandon rules if unable or unwilling becomes an unchecked legal doctrine. Every powerful state gets a free pass to conduct military operations everywhere in the world, so long as to point out non-state actors as a pretext. International law must evolve to address non-state threats, but it must do so in the way that does not simply becomes new dress code of imperialism.
Thank you so much, Ashwini, for your insight. There is a saying attributed to ancient Rome: laws are for the weak, the strong do as they please. 2000 years later, international law is still wrestling with it. Consider the record. The United States, a founding member of the United Nations and a permanent member of the Security Council, invaded Iraq in 2003 without Security Council clearance. The UK joined. Neither faced any legal accountability. Russia annexed Crimea in 2014 and then invaded Ukraine in 2022. Both in clear violation of Article 2.4 of the UN Charter. It vetoed every Security Council resolution attempting to hold it to account. China has used the threat of force and actual force in the South China Sea in direct contravention of UN clause and the Rule 950 as well. Is international law simply toothless when great powers are involved? The Nicaragua case suggests otherwise, at least in principle. The ICJ in 1986 did not flinch. It ruled against US when it attacked Nicaragua when US countered the counter-rebels and attacked the Nicaragua harbor as well as the economy of Nicaragua. The court was unambiguous. These acts were violation of the international law on the provision of the use of force or non-intervention. But then the US simply refused to comply. It withdrew from the proceedings. It vetoed the Security Council resolution that would have enforced the judgment. Nicaragua eventually discontinued in case under US economic pressure. This is the fundamental vulnerability of the international law. It can declare the law, but it cannot enforce it. There is no compliance as such when we talk about permanent members. The enforcement mechanisms are held hostage by the permanent members of the Security Council. What is the legal answer? Some scholars argue for more robust use of the General Assembly. The United for Peace resolution, which allows the United Nations General Assembly to recommend collective measures when the Security Council is paralyzed. This was used in the Ukraine case after Russia's 2022 invasion. When an overwhelming majority of states condemned the war, it had no binding force, but it carried significance, moral and diplomatic weight. Others point to universal jurisdiction. The idea that some crimes are so grave that any state can prosecute them regardless of where they occur. The ICJ's jurisprudence on alpha omnes obligations owed to an international community as a whole also points in this direction. The honest answer is this: compliance with international law by great powers is primarily political and not legal. International law works best as a language of accountability, a standard against which state conduct can be measured and condemned, even when it cannot be stopped. And sometimes even that is enough. The ICJ's ruling in Nicaragua case gave legal legitimacy to the decades of criticism of the US foreign policy. The provisional measures of South Africa versus Israel have reframed global discourse on the other. Law saves politics even when it cannot comply. Thank you.
India's constitutional and foreign policies tradition is rooted in Panchsheel, the five principles of peaceful coexistence, which include mutual non-aggression and non-interference in each other's internal affairs. This is not just a diplomatic priority. India has consistently voted against unilateral for the use of force, opposed humanitarian intervention without UNSC authorization. It maintains strategic autonomy, refusing to automatically align with either Western or Eastern blocs on these issues. Looks at India's abstention. India's abstain on UNJ resolution condemning Russia's invasion of Ukraine. India's abstain on resolution regarding humanitarian situations in Gaza. This is not indifference. This is a principle. It's a controversial stance that UN's charter framework must be applied equally or not at all. India has also been directly involved in ICJ proceedings, relevant use of force in jurisdiction. The Tata case, India vs Pakistan, decided on 2019, deals with consular access to Vienna Convention on Consular Relations India successfully argued before the ICJ, and Pakistan had violated its obligation to inform Kulbhushan Jadhav of his right to counsel assistance when he was denied on charges. The ICJ ruled in India's favor, ordering the review of Jadhav's conviction. It shows India's willingness to use international legal mechanism to hold other states accountable when India's nationals are affected. Second, it demonstrates that smaller states and developing nations can access ICJ jurisdiction effectively. The court is not exclusively a tool of West. India's approach to humanitarian intervention is also shaped by its own experience. India did intervene military in East Pakistan in 1971, contributing directly to the creation of Bangladesh. This stopped one of the largest humanitarian atrocities of the 20th century. But India justified it primarily on ground of self-defense, cross borders, refugee flow, and threat to Indian security, rather than humanitarian intervention per se. India was and remain uncomfortable with the idea of humanitarian intervention. Justification alone can override sovereignty. India's position essentially is the UN Charter framework must be respected. The Security Council reform and more representative is the legitimate authority for collective force and unilateral humanitarian intervention, however well mentioned, is precedent too dangerous to establish. In a world where India is increasingly a major power, its voice on this question will carry more weight. How India will shape or resist the evolution of these norms will matter now.
Thank you, CK, for your insights. I want to close this discussion by asking the hardest question of all. Does the International Court of Justice actually work? The ICJ is the principal judicial organ of the United Nations. It has two functions. It settles disputes between states, contentious jurisdiction, and it gives advisory opinions to UN organs. It cannot arrest anyone. It has no army. It has no sheriffs. Compliance with its decision is ultimately voluntary. So what is the point? Let me make the case that the ICJ matter enormously and then tell you why it's still not enough. Start with the Corfu Channel case of 1949, the very first case of ICJ ever decided. Albania was found responsible for mines in its territorial waters that damaged British warships. The court established the foundation principle that states are obliged not to allow their territory to be used in ways that harm other states. A principle that has echoed through international law ever since, from nuclear testing disputes to cyber operations. Then come the Nicaragua judgment of 1986. The court issued a comprehensive ruling on the law of the use of force, collective self-defense, non-intervention, and state responsibility. It defined an armed attack narrative. It said that the supply of arms to rebels does not constitute an armed attack. It insisted on proportionality. These rulings became the foundation for how customary international law on the use of force is understood today. Every international law textbook cite Nicaragua. Now move to 2024, the South Africa versus Israel proceedings were live, ongoing, and watched by the entire world. The ICJ issued provisional measures in January 2024, finding it plausible that Palestinian rights under genocide conventions were at risk. It ordered Israel to prevent genocide, allow humanitarian access, and preserve evidence. It then issued a second and third set of measures as the situation deteriorated. The court also issued a landmark advisory opinion on 23rd July 2025 on the obligation of states. The board also issued a landmark advisory opinion on 23rd July 2025 on the obligation of states in respect of climate change, from which the principle that the states are bound by international law to prevent environmental harm is now extended even to armed conflict contexts. What has ICJ ever achieved? Israel has not complied fully. The US has shielded Israel at the Security Council, and yet the ICJ's ruling have deframed the entire global discourse. States had to publicly justify arms sales. Domestic courts have been asked to book weapon transfers, block weapon transfers also, sorry. Political leaders have been forced to respond to the legal record. The ICJ is not a policeman, it is a mirror. It holds up international law and says, this is what the rules are for. This is how you conduct measures against them. You may ignore the mirror, but the image still remains. The value of international adjudication is not primarily enforcement, it is legitimacy. It is the ability to say with authority that a state has acted unlawfully, and to have that judgment stand in the record of history. As we close the discussion, the question is not whether the ICJ is perfect. It is not. The question is whether we want a world governed by law or a world governed by force. And if we choose law, then the ICJ, for all limitation, is the best instrument to have. Thank you very much.
I respectfully disagree with you, Yash, on the point that ICJ has been effective in complying the international law to the forefront. As has been seen with the case of Nicaragua versus USA, even after the ICJ gave the judgment, the USA walked away and did not follow it and vetoed it in the Security Council. So what I mean is that the international law becomes ineffective, and ICJ has also been ineffective in making the international law compliance better.
But Saurabh, when you say that ICJ has become incompetent in dealing with the problems, I would like to say that the fact that states violate the law does not mean that law does not exist. States commit murder. We do not abolish prohibition on murder. If a person is said to have committed murder, but the law is still there, still people do that. That does not mean that the law is not there. And the US invasion of Iraq was condemned internationally precisely because the Charter and the ICJ say so. They say that if there is such a forceful aggression act, then it should be condemned. And that is the reason that the acts were condemned. If there was no ICJ and if there was no international law, they would not have been condemned.
Again, Zuman, I have a point to counter you on this. When you say that violation does not amount to validation, I mean without the law getting enforced, there is no point in it getting validated. When the law becomes unenforceable, its validity is questioned. It is a natural course of action.
But Saurabh, when you were talking about that R2P is not just Western imperialism, South Africa, which is a developing nation right now, it used R2P logic at the ICJ against the powerful occupant force. Is that imperialism according to you? No, right? The global South is wielding this doctrine and not just the West. The abuse of the R2P process in Libya does not invalidate it, and by that logic, abolish the self-defense that became powerful states abuse that too.
Rather, R2P's biggest real world test was Libya 2011. A Security Council mandate was obtained correctly, then expanded into regime change. The result was a decade of civil war. Russia and China have cited Libya to block every humanitarian resolution since R2P without council constraint does not protect people, it destabilizes them.
I agree with Saurabh. When Pradyuman and Mustafa are defending the legal formalism of international law, they are forgetting that we have always been saying that we just need to reform the council, and this has been happening since 1945. But still the Kosovo incident happened, and we could not do anything because the world could not wait for the reform that we are all mentioning. Sometimes the moral imperative is immediate, and the legal machinery, which is lagging and slow, is not able to maintain with the status quo. The Kosovo advisory opinion itself said unilateral declarations of independence do not violate the international law. The ICJ left the door.
So when you were emphasizing on Nicaragua versus USA case, what I have to say about that is that ICJ ruling in Nicaragua versus USA did not stop the US immediately. It gave every subsequent critic of US foreign policy a legal foundation to stand on. The provisional measure in South Africa versus Israel have forced states to publicly justify arms sales, trigger domestic court proceedings, and reshape global discourse. Law shapes politics in long run, and even when it cannot compare it in the short run.
Thank you so much, yes, but I would like to continue what you said. saying that when we say that international law is not able to do this or do that, or have an enforcement mechanism like a sovereign law is there, like a local law is there, we forget one thing, that the reason that these big states like US who have enormous military and financial power, they also have to bend to international norms, to come into press conferences, to come into media and say that we are not doing wrong. They are so mighty countries. What reason do they have? Why do they have to justify to the world what they are doing? The only reason is that international is existing and the ICJ's ruling are binding and are enforcing.
I agree with your point on that, Pradyuman and Yash. A simple question to you, both of you guys. So basically, what you are suggesting is that international law should be post facto law. That when an act happens, and then you will try follow later on. This is wrong in every sense. Now I will give you an example and you can understand from that. So basically, a murder happens in a neighborhood and police arrives later. Now, how can that police have prevented the murder if the law has not been enforced?
I agree with Saurabh. The idea that rules matter even when following them produces catastrophes, I don't agree with that. Rwanda happened inside the legal framework. Pradyuman is defending. 800,000 people died because the answer was sovereignty first. A legal system that protects genocidal governments has a legitimate crisis, not just a political problem.
Bhatia, I would like to point to you that when you said in your speech that the R2P has no binding legal force, you are technically correct that R2P is not a treaty. But the Genocide Convention is, and the ICC's provisional measures in the South Africa versus Israel case are binding under that convention. So the R2P's legal teeth are coming through the existing treaty law. The political declaration is the current norm, and the Genocide Convention is the enforcement mechanism for it.
I agree with you, Leader. And as Vineet said about that the legal machinery's inactions resulting in a lot of catastrophes, I would like to say that there has been the answer since we can say that Kosovo happened because the world could not wait for reform. And sometimes when we are saying that the legal machinery could not get the evolution on time and could not act, it could also be because the legal machinery is slow and the opinions that are being given by the ICJ, they may not get the effective or the fast implication that they should, but still there has been quite a good amount of enforcement by the international law to a lot of other massacres and other catastrophic incidents that have happened. Current examples we can take of Gaza and Iran.
I would like to proceed with one of the disagreements that I make towards what CK opined about India's own 1971 intervention in East Pakistan, where India used force on foreign soil without Security Council authorization. If non-interference is the rule, India broke it too, and the world is grateful it did. Because Bangladesh, which was an independent state, that was an outcome of that interference. Because it stopped one of the worst atrocities of the 20th century. Principles are tested and their hardest case, not their easiest ones.
But Ashwini, India's position has never been that atrocities don't matter. It is that unilateral intervention set the precedent that smaller or weaker nation cannot survive. If powerful nation can intervene on their moral judgment, then India itself become a vulnerable to some logic from the neighbors. The rule must protect everyone equally, or else protect it.
भैया बस 2 मिनट का बचा हुआ है
सीके वो पीछे ही लाइन
बट अश्विनी से स्टार्ट और सुनो सीके तेरे उसके बाद खत्म कर
इसके बाद वो निकाल देंगे उससे एक
इसको एक लाइन बोल देता फ्रेंड
नहीं तू 89 बोल दियो और उसके 89 कर दूंगा मैं
क्या बोलेगा?
अरे मैं ऐसे
सुना मैं ऐसे बोलूंगा कि
अरे कुछ भी बोल देना यार कर दो कुछ भी
अरे अच्छा से निकल रहा था ना क्लॉड से 3 पॉइंट
ठीक है अभी इसको बोलना मैं एक लाइन बोलूंगा उसके बाद कर देंगे
हां ठीक है पूरा स्टार्ट करो
अरे
But starting scene. But Ashwini, India's position.
अरे लोग थोड़ा 3 सेकंड रुक वरना कट कर देंगे
3, 2
1.
But Ashwini, India's position has never been that atrocity doesn't matter. It is that unilateral intervention set a precedent that smaller or weaker state cannot survive if powerful nation can intervene on their moral judgment. India itself become vulnerable to some logic from its neighbors. The rule must protect everyone equally or it protect no one.
I must say that this was a very interesting conversation and everyone has contributed many interesting points. And it is clear from this group discussion that, that the law is clear. However, political will, it is the political will which is absent. So, reform is the way forward and this can be concluded from this group discussion.
Thank you, Bean, for concluding it for us. I think we all can agree if we keep continuing the debate would last very long. I think we should conclude now. Thank you everyone for this. Hopefully the viewers of this video also love the discussion. Thank you everyone for coming.